Please be seated.
Ready for the jury? Pardon? You can bring them to the door, please. Line them outside the door.
Yes, sir. You ready, Your Honor?
Not yet. Okay, jury.
Sir.
Judge,
Yes,
take
ma'am.
the court's indulgence one
Another
second.
indulgence.
We might have a matter for the court.
All right.
Judge, a while back, and I believe again shortly before the trial started, we had made a motion in limine regarding character evidence of the victim in this case, Mr. Scott. Knowing, of course, that the autopsy results would yield that there had been some cocaine used by Mr. Scott, and I believe Mr. Savage crossed Mr. Scott's son about his knowledge of prior cocaine use. So certainly we have known that that would be an issue coming out in this case. However, my concern with our next witness, who is a forensic toxicologist, is the cross-examination, as we have seen conducted with other witnesses throughout this case, which assumes facts that are not in evidence, and frankly, in this case, won't be coming into evidence. Questions, it's the old, were you aware that he beat his wife kind of question? Well, no, because that didn't happen, and that's not in evidence and won't be. We have a distant 30-year-old discharge, general discharge from the military for marijuana use. We have a record from an employer from some years ago for an accident at work where there was a drug test performed that was positive for cocaine. And that's the extent of the history that I'm aware of.
What year was it, did you say?
I'll have to get that year.
November 14th, 2014.
So just over a year from this use. I don't believe that
Less than 6 months.
oh, I'm sorry. I don't believe that equates to chronic cocaine use. And so I would ask that the court, in line with its ruling in limine, that cross-examination regarding the terminology chronic user and things like that not be allowed because it's more prejudicial than it is probative in the situation.
Defense?
The medical testimony is that chronic users have different effects than acute users. The questions then were, what attempts did the state take to distinguish between acute and chronic, knowing that there's a difference? As Ms. Wilson said, they've known about this for 15, 16 months. So we would request that the court not limit us based on the state's failure to do their job, so that medical testimony can be given about the difference between chronic user using cocaine and acute user using cocaine, knowing that that cocaine was part of this situation. So we have an incident.
Cocaine was part of what situation?
The incident of April 4th, 2015. There was cocaine and cocaine metabolites, coethylene in the body and peripheral blood. And if the state attempts, as I believe they are, put up an expert that says this doesn't have much of an effect, the medical science is such that if these are chronic cocaine user, that the effect would be much different than an acute user. In addition to the incident on November 14th of 2014, less than 6 months before this, there is evidence that we will have that he was tested on April 29th of 01 positive for cocaine, and that he had a previous experience with drugs while he was in the military. So, we think it's essential to understand the pain resistance of Mr. Scott on April 4th, 2015, as well as the potential for what the medical world is calling excited delirium, which took place on April 4th, 2015. That is the purpose of our question. And they had the ability to...
You said medical delirium.
Excited delirium.
Excited delirium. What is that?
It's a medical term where, because of the combination of drugs and alcohol, on certain individuals, they can have character, they can become highly aggressive, they're pain resistant, they act in a very short period of time, in reaction to authority, in reaction to stress. We believe that that is exactly what happened because of the medical condition of Mrs. Scott on that morning.
Do you have an expert that you believe will offer admissible testimony that Mr. Scott suffered from excited delirium on the date and time in question?
Dr. Thomas, who's the medical examiner, Mecklenburg County in Charlotte, we anticipate will testify that based on his training experience, that is what Mr. Scott was experiencing on more than 2015. Thomas Owen is the medical examiner of Mecklenburg County. I think we provided that information to the board. The state is that correct?
Ms. Wilson?
Your Honor, again, the military discharge, I believe, was related to marijuana, not cocaine. And again, under a 403 analysis, a 2001 positive test and a 2014 positive test do not a chronic user make.
You want, I am to determine that based on a matter of law or what?
I think that, well, we certainly aren't there yet. And Mr. Savage says he has some doctor who's going to testify as to that, and that'll be something we will ask to take up out of the presence of the jury for sure, whenever he gets to that point in his case when he wants to call that expert. I believe he mentioned that Dr. Owens is a medical examiner or a pathologist,
Yes.
not a forensic toxicologist.
He's also learned in hospital.
All right, anything further?
I don't want to be repetitive, Judge, but the evidence to confirm the chronic use is in the hands of the state. And the state knew that this was an issue for 15 months.
What evidence are you referring to?
The hair. The testimony was that the hair was used for multiple purposes. It was used for toxicology, it was used for trace evidence, hair comparisons, DNA, but included among them was the use of chemicals. I believe is what I said, so I didn't say drugs, but chemicals.
Anything further?
No, sir.
All right, the motion to eliminate is granted. That evidence cannot be offered until such time as the court has conducted a hearing and determined the admissibility of this expert opinion on the theory that Mr. Savage espoused. And it cannot be through a cross-examination of this witness unless this witness confirms through their own opinion that this is an area of expertise and the court determines that that is admissible. In short, the motion is granted. If you'll bring the jury.
We may want to hire this expert on whatever area this expert is on.
All right.
Do that now?
Yes.
Okay. Jimmy Garvin?
No, just have them go back to the jury room.
You swear from the testimony you shall give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your first and last name and spell your last name loudly, clearly, and clearly.
My name is Demetra, D-E-M-E-T-R-A, Garvin, G-A-R-V-I-N, and I'm commonly known as Demi, D-E-M-I, Garvin.
And what is your occupation?
I am currently a forensic toxicologist and also a quality and business development manager.
Can you tell the court what your educational background is?
I have a Bachelor of Science in Biology from Furman University in Greenville, South Carolina, and a Doctor of Clinical Pharmacy from the University of South Carolina College of Pharmacy in Columbia.
And Dr. Garvin, what specific training do you have in the field of forensic toxicology?
I am, pardon me, I have had, this is my 32nd year in forensic science, specifically forensic toxicology and drug chemistry, and I have obtained my pharmacy license here in South Carolina, board certification in forensic toxicology, have taken numerous courses beyond both of my degrees in pharmacology, toxicology, instrumentation associated with the science, and that would be probably the sum total of my additional training.
Where are you employed now?
I'm currently employed with Forensic Science Network in Columbia. It's a consulting firm that provides forensic services, more specifically toxicology, forensic toxicology and criminalistics services to pathologists, coroners, law enforcement, and the legal community in South Carolina and in Georgia. And also, I'm employed as a business development and quality manager for a company called DPX Technologies in Columbia, South Carolina.
What is that, DPX Technologies?
DPX Technologies, DPX is an acronym that stands for Dispersive Pipette Extraction Technology. It is a technology that was developed by one of my colleagues, another forensic toxicologist, Dr. William Brewer, who holds the patent in the technology, and essentially it is used in a variety of practice settings to include clinical medicine, forensics, food safety, and provides an extraction device for testing in those areas, pharmaceutical industry as well.
Before the Forensic Science Network and before DPX Technology, were you employed by SLED?
Yes, I was a staff forensic toxicologist and also operating as a clinical toxicologist for several years, as well as a drug chemist for the South Carolina Law Enforcement Division for 16 years.
And after you left SLED, you went to Richland County?
Yes, in 2000, I was employed with the State Law Enforcement Division from 1984 to 2000, and then in 2000 I transitioned to the Richland County Sheriff's Department, where I assisted Sheriff Lott in the development of what ultimately became a full-service forensic sciences laboratory. And during my 15-year tenure there, I was a supervisor of the drug chemistry section, then became the assistant laboratory director, and finally the laboratory director.
And how many forensic toxicology cases would you say you've handled, if you could guess?
Thousands.
And have you had any continuing education in the field of forensic toxicology? And do you often teach in that field?
Yes, sir. I do teach at the University of South Carolina, a forensic science course. Pretty much have done that yearly since about 2000, I think, thereabouts. And I am required to obtain continuing education and have been required to do so for a number of years, yes.
And have you been qualified as an expert in the field of forensic toxicology?
Yes, ma'am.
And do you know how many times?
At least 200 times.
Okay. Your Honor, at this time we'd offer her as an expert in forensic toxicology.
Says the defense.
Therefore, go ahead with
Yes.
the field of your expertise encompasses what? What is forensic toxicology expertise? What's contained?
Forensic toxicology is the science of drugs, alcohols, and other poisons which are identified from biological matrices in both living and deceased individuals. And then once those compounds are identified and perhaps quantitated, that is a concentration or an amount is associated with them in the biological matrix. There is an interpretation that follows from that, and then if requested to do so, the forensic toxicologist would then provide that information in a court of law.
So are you familiar with the lab analyses of biological material in terms of foreign substances? Is that correct?
Yes, sir.
And you're familiar with behavior?
I would say that the effects of drugs, alcohols, and other poisons, the effects on behavior are a component of forensic toxicology. Yes, sir.
And what specifically academic training or field experience have you had with the behavior of drug addicts or people who use foreign chemicals in their system?
Well, behavioral effects in association with drugs, alcohols, and poisonings are a subdiscipline of what one learns as a forensic toxicologist in his or her training, and I would say that was a component of my training and experience in the field.
So you have made observations of people who are under the influence?
Well, by example, early in my career, as a function of my training and the development of my expertise in driving under the influence cases, I did in fact participate in dosing trials with respect to the use of alcohol in individuals to observe effects associated with increasing concentrations of alcohol. Yes, sir.
How about the use of cocaine?
No, sir.
Do you have any experience at all to associate amounts of cocaine with behavior?
Insofar as what we are taught didactically in terms of increasing concentrations of the drug under specific conditions, the answer would be yes. By physical observation, the answer would be no.
You're familiar with the medical research in cocaine usage, that chronic usage of cocaine has a different effect than a singular use of cocaine. Is that correct?
I'm not sure I understand the question.
Are you familiar with the medical literature in cocaine use, distinguishing between a chronic user and a single-use user behavior?
Behaviorally? To some extent, yes, sir.
And so you are in a position to testify as part of your training and experience on that issue?
I don't know unless I'm posed the question.
Fair enough. I succeeded with that.
Thank you.
Any objection as to this witness being qualified in the field offered?
In the field of forensic toxicology.
Yes,
Okay.
she's admitted.
And, Your Honor, I can continue down my
All right.
questions, and we have no intent to get into behavior with this witness, and that was the purpose of the motion in limine. Dr. Garvin, your firm, Forensic Science
Well,
Network.
I don't need to know all of her entirety of her testimony. It's the, granted the motion in limine, if this witness had some opinion based on her review of the record that Mr. Scott was a chronic cocaine user, whatever that means, and that she has some view regarding what constitutes excited delirium, and that he suffered from that on this day, then I will rule on that issue if no one has posed any questions to her that would make me believe that she has any view on that issue at this point.
That was the purpose of my motion, Your Honor. I don't believe that she does have that view. That's not necessarily her field, but what we have seen happen time and time again is these questions being asked and hung out there when Mr. Savage knows that this isn't the witness, or that the witness who's on the stand is not the witness who would be the one to speak to that. So I can ask the witness, Dr. Garvin, you work with FSN, who works with pathologists, is that correct?
Yes, ma'am.
And you, in your role with Forensic Science Network, your firm did an analysis with regards to the cocaine levels in Walter Scott as supplied to the medical or the pathologist.
We have an objection.
What is the objection?
The Crawford objection, this witness did not perform the testing solicited suppressed.
Well, you're objecting to, restate the question, please?
Did your firm become involved in the analyzing the results of the test from NMS labs?
After the testing was performed on the submitted biological specimens, Forensic Science Network, myself and my colleague, Dr. Brewer, were involved in the interpretation of the results from the toxicology testing.
So is that what forensic toxicologists do? Analyze results?
They can perform the testing, and they can also provide the interpretation of the results, or both.
Okay. And in this instance, NMS labs performed the testing, correct?
Yes, that's correct.
And then your firm, you and Dr. Brewer, performed the analysis of those levels?
The interpretation of the results from the testing.
Okay. And your interpretation was then passed on to the pathologist for their reliance for their autopsy?
Yes, in this case, Dr. Brewer did the evaluation, and that was provided to Dr. Tormos at the Medical University.
And you have been involved in a review of all of that?
Yes.
Okay. And is it common in your field of forensic toxicology to review tests performed by others?
Yes.
And to review interpretations and to provide your own?
Yes.
And was your interpretation of the results from NMS the same as Dr. Brewer's?
Yes.
Now, with regards to the results of the test,
This is what Dr. Brewer's.
that's what I was,
Okay.
that's where I'm
All right,
going.
thank you. Thought you were moving to something else.
Not exactly. So Dr. Brewer, with regards to the blood that was sent by the pathologist to NMS for a tox screen, can you tell the court what drugs were screened for?
The testing that was requested was, the analysis code is what is known as an 8052B. The B stands for blood, and that is described as an expanded postmortem toxicology panel and includes a number of compounds which include alcohols, common drugs of abuse, and a number of therapeutic agents and their breakdown products.
And those tests, are they sometimes used by, or the results of those tests, sometimes used by pathologists to determine a cause of death?
Yes.
Or a contributing factor of death?
Yes.
And it's common in your field to help interpret those levels to see if they had an effect on the cause of death?
Yes, to assist in the interpretation and serve as a resource to the pathologists and coroners. Yes.
And with regards to the blood of Walter Scott that was tested by NMS, what were the levels of drugs that were found in his samples?
For the testing panel that was performed on the submitted peripheral blood sample from Mr. Scott, there were 3 compounds that were identified with associated concentrations, and they were cocaine, in the amount of 36 nanograms per milliliter, cocaethylene in the amount of 26 nanograms per milliliter, and benzoyl-ecgonine in the amount of 1,300 nanograms per milliliter.
Okay. And with those levels, first of all, let me ask you, before we get to the levels, the type of sample that was used for the test, the peripheral blood, you said.
Yes.
And is that a best practice for analyzing for drugs?
It is considered the use of a peripheral blood sample, whether in the context of an autopsy or in the case where an autopsy is not performed, is considered an appropriate specimen because it is obtained as far away from the chest cavity or central portion of the body as possible. The reason for that is very often it represents a better window, if you will, of insight into what the actual concentration of a particular drug might have been on or about the time of death, whereas samples that are drawn, blood samples that are drawn from the heart or surrounding area have an increased risk of having drugs reported at higher concentrations or perhaps being contaminated if there's trauma to the body.
Okay, so with a gunshot wound or several gunshot wounds, in your experience, it would be better to have peripheral blood used than blood from the center cavity?
As toxicologists, I recommend to the greatest extent possible to obtain a peripheral blood sample whenever possible.
And you've seen the autopsy in this case?
No, I was not present at the autopsy.
Well, I mean, you've seen the report that describes the timing of the sample collection.
Actually, no, I have not seen the autopsy report.
Okay, so if the autopsy was performed within 25 hours of Mr. Scott's death, does that affect the ability to get an accurate reading of cocaine levels in the blood?
The longer the postmortem interval is, which is defined as the time from the death until the time the sample is collected, the longer that period is, the more time elapses, the more there can be an effect on the concentration of a drug or its breakdown product identified in a biological specimen, particularly blood. It is drug dependent, and there are other factors that can influence the result. But again, to the greatest extent possible, we want to have a shortened interval, and a period of about 24 hours is not uncommon.
In looking at the results, what can you tell us about the time of ingestion for cocaine?
Yes, Your Honor, unless we receive a report of the 5 of this witness's testimony, proposed testimony, we have no report.
Response?
Your Honor, they have the brain tissue report from NMS that we actually got from them, and they have what's been marked Rule 5, SAW 894, 895, 896, and 897. Regarding the tox results, we're now asking the witness whose firm was involved and who has examined the analysis, along with Dr. Brewer, what these results mean. There hasn't been a report as of that, but she certainly has been available, and as has Dr. Brewer, and I believe Dr. Brewer has spoken with Mr. Savage.
The listener seems to know a lot about me, but I don't know anything about this. I've never received a report from Dr. Brewer other than the toxicology report that he did not perform. It was performed by NMS, but I don't have any case-specific report from Dr. Brewer and NMS from the witness regarding the interpretation that one might have regarding the information provided by NMS.
There is no report, Your Honor.
We object to that.
Not overrule the objection.
With regards to the levels, what the levels for cocaine and cocoethylene and the benzo, can you tell the court what you can tell from those levels regarding the timing of the cocaine and alcohol ingestion?
Well, there is no alcohol reported as being present. However, the compound cocaethylene is formed when cocaine and alcohol or ethanol are present in the circulation together in the body. So at some point prior to the collection of this specimen, Mr. Scott had consumed alcohol in conjunction with cocaine. Insofar as the timing of the use of cocaine and alcohol, for that matter, there is no way to determine that from the toxicology results.
Okay, you mentioned that there was no alcohol, but that the cocoethylene meant that alcohol and cocaine were present together at some point.
Yes, that's correct.
The alcohol would have already been metabolized.
Yes, it was likely burned off by the liver or degraded, if you will, and no longer present. That's correct.
Leaving just the byproduct of cocoethylene, correct?
Leaving just the cocaethylene, yes.
Okay, and then the cocaine itself had not burned off yet. Is that correct?
No, there was still parent cocaine at the time the sample was collected.
And so with these levels, you can't pinpoint timing. Can you pinpoint the mode of ingestion?
The route of ingestion? The route of ingestion?
Yeah.
No, ma'am.
So you can't tell if it's smoked, snorted, IV,
No.
regardless?
No.
Is there anything about these levels that suggests, even though you can't give a precise time, is there anything that suggests that it would have been within several hours to even many hours the night before?
Either is possible. Yes, that's correct.
How about many days before?
You'd have to be more specific.
2 days, would that be possible?
It's possible.
Probably not.
It's difficult to say. It is possible, yes.
So, but more likely within hours instead of days?
Hours to several days.
Now, you also have reviewed the NMS lab reports issued to the Savage firm regarding brain tissue in this case. Is that correct?
Yes, ma'am.
And the drugs that were tested for in the brain tissue test, was that the same type of panel that was run for the blood?
No, it was not.
What was the difference?
The testing that was performed in the peripheral blood sample, which was collected at autopsy, was a more expansive panel, if you will, a more extended panel. It, as I testified to earlier, it contained, it included alcohols, therapeutic drugs, and drugs of abuse. The testing that was performed, there were three, to be more specific, there were three matrices that were tested in the second testing event, and they included submission of a fluid which was documented to be formalin. There was neat, there was fluid documented to be formalin which appeared to have bathed the brain tissue, and then there was the brain tissue itself. So there were three items that were tested in the second testing event. And In that scenario, the fluid which bathed the brain as well as the brain tissue, the panel was more truncated and included only drugs of abuse and alcohols. The fluid, the neat formalin, that is a standard or reference formalin, was tested only for the presence of cocaine, cocaethylene, and benzoyl-ecgonine.
Okay. Now, the results from the brain tissue test, do they do anything to shed more light as to the timing of the ingestion of cocaine by Mr. Scott?
No.
Does it do any more to tell you about the dosage, as in the amount of cocaine ingested, or the route or the mode of administration?
No.
Are the results from the brain tissue testing what you would expect to see after having seen the testing that was done on the blood?
Well, they're independent matrices. The only conclusion that can be drawn is that at some point Mr. Scott administered or was self-administered or was administered cocaine. Cocaine crossed into the brain and then subsequently was broken down to benzoyl-ecgonine, which can only come from cocaine.
And that's what happens when people use cocaine. It gets absorbed into the brain.
Yes.
That way.
Yes.
Okay. Does anything about the toxicology results from the peripheral blood or the brain tissue give you any insight as to whether the use was chronic or acute?
No.
That's all I have, Your Honor.
Mr. Savage.
Without question, this witness, Your Honor, the report that was delivered at the request of the defense is only known to this witness and to the solicitor because this court instructed that if we were going to test the brain sample, we had to give them a copy. Case law, I believe in South Carolina, is that our testing doesn't have to be shared with anyone for any purpose, unless we determine we are going to use that testing in litigation. So we would object to the testimony of this witness or any other witness about what information our firm has, unless we intend to use that in our case in chief. That testing was not done in accordance with Rule 5. The report of the testing was not done in accordance with Rule 5. It was done in accordance with instructions of this court. So we object to any testimony of this witness regarding the brain exemplar that we had litigation with it before we sent it to NMS. In addition to that, Your Honor, this witness is testifying without a report having been provided, and I know the court has ruled on that, but I do want to address that we have a report from the people who actually did the testing of their interpretation of the results, which is in conflict with this witness's testimony. So it's our belief that what the solicitor has done is ignored their test that they had performed, not a defense test, performed by NMS that gave the result of the compounds found in Mr. Scott's body, along with a written report by Susan Copcam, certified scientist, signed on April 16th of 2015 at 8:51 in the morning, regarding the interpretation of those results. So this witness did not participate in the testing of the compounds, did not observe the testing of the compounds. We believe, therefore, it has a cooperative issue involved. Now this witness, regardless of the people who did It's a shotgun. The state appears to be seeking the results that they want from as many different parties as they can. This is the report, and it contradicts what this witness states.
In response by the state.
I don't know of any contradiction in this witness's testimony versus what's in the reports. And as far as the rules go, Your Honor, under Rule 703, as an expert, Dr. Garvin can rely on the reports of others, and Mr. Savage certainly didn't have a problem with Dr. Torres relying on it. This is what they do. This is how the information gets to the pathologist, and the pathologist incorporates it into their autopsy results. All of the things that Mr. Savage raises are fodder for cross-examination.
The difference being I don't have a report from this witness. I have a report from Dr. Barnes. I knew what she has done. If I knew that this witness is going to testify in contradiction to the previous report, I would have brought in another. I would have brought the witness in from Philadelphia. We've exchanged expert lists. It's nothing that we have that the solicitor doesn't know about.
That's certainly not true, and we've had that discussion as recently as lunch. There are many things that they have that we don't have and that we aren't able to see.
And we
But,
understand the rule. If we're going to use it in our case in chief, we'll give her a report.
which is why we gave Mr. Savage Dr. Garvin's CV.
This is a motion in limine hearing, the purpose of which is for the court to rule on the question of whether Mr. Savage can cross-examine this witness, raising the question that Mr. Scott was a chronic cocaine user and suffered under a condition referred to in some areas as excited delirium. This witness has given no indication that she has any view or has any opinion well, I guess specifically, I can ask you, ma'am, based on the history that you've reviewed and the facts stated here in this hearing of a marijuana arrest 30 years ago, a discharge from a job in 2014, an 01 incident of possession or use of cocaine, and cocaine being in Mr. Scott's system when he died, do you have an opinion as to whether or not, to a reasonable degree of medical certainty, as to whether or not he was a chronic cocaine user?
No, sir, I do not.
And with regard to this excited delirium, are you familiar with that term?
Insofar as it is associated with cocaine, yes, sir.
And do you have any opinion, do you believe that you're competent to offer an opinion as to whether or not he suffered from that at the time of his death?
I don't believe I'm in a position to render an opinion on that.
Yeah. Based on this hearing, the motion is granted, and counsel is to refrain from cross-examination of this witness with regard to contending or probing her on whether or not Mr. Scott was a chronic cocaine user, and whether or not he suffered under excited delirium. The testimony does not meet the reliability test. Any response would be speculative. And of course, the jury will be instructed at the end of the case that questions asked by the lawyers is not evidence, but has been demonstrated during the course of this trial up to this point. questions in the nature of testimony has been rendered, and in many instances in such a way that a court instruction would be meaningless in the face of the manner in which the questions are posed. I think that the state is directly on point that to allow cross-examination would be, in these areas, would be more prejudicial than probative. And so I grant the motion.
I realize you ruled, Your Honor, but I'd ask the court's indulgence to, I want to argue further, but I want to point something out to the record, if I may.
Sure. For the record, yes.
Dr. Garvin, are you familiar with testing for foreign substances in hair samples?
Yes, sir.
Are you familiar with testing brain samples that are frozen brain samples to test for foreign substances?
Yes, sir.
And is it accurate to say that frozen brain sample would give a more accurate analysis of the compounds in the brain that would affect behavior than a brain sample that's kept in formaldehyde for some years?
I would say that that is, in my opinion, would be specific to the compound in question.
Yeah, and you'll be able to cross-examine her along this line. I'm specifically referring to the motion in limine. Yes, sir. All right. All right, well, we've earned a 3-minute stretch or something in the meanwhile, so we'll just take a 5-minute break and then hopefully bring the jury.
Yes, sir.